Ms. Morelli, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine.
A daughter accused of brutally attacking her own mother, not once, but twice. Blood on the victim's face, a history of violence, and a judge who's had enough. This isn't just another assault case. This is a pattern of family violence that's been brewing for years. Today, we're diving into a shocking courtroom hearing where a mother faces her daughter. Boundaries are set, and the stakes couldn't be higher. Will this defendant get one more chance, or is jail time inevitable? Stick around, because this case takes some wild turns you won't see coming.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
Okay. The officer spoke with the complainant, who is the defendant's mother, and who was also I apologize. Do you want me to keep going?
Go ahead.
Okay.
Sorry.
No problem. The officer spoke with the complainant, who is the defendant's mother, and was observed to be bleeding from her mouth and face. The complainant stated the defendant physically attacked her in the defendant's kitchen after a verbal argument about the complainant calling out the defendant for taking drugs. The complainant stated the defendant was beating the living hell out of me. The complainant stated she doesn't know exactly how many times the defendant struck her, so that the defendant hit her numerous times with both hands and that she felt pain. The complainant stated they both had been drinking and had a couple margaritas, but that it was not the reason for the assault. The complainant stated she ran out of the defendant's house and back to her home, which is only a few houses down the street, to call for help. The complainant stated the defendant has a history of assaulting her.
There's a prior assault of a family member. Is that the same complaining witness? Let's see. Second assault of a family member against the same person. Ma'am, I'm going to find that there's probable cause to go forward with your case, and I'm going to tell you now, I'm going to do everything in my power to protect every single person of this county, and if that means putting you in jail, I'm going to do it in a heartbeat. Do you understand? Yes, I'm sending you now for a drug test. I want to know what, if anything, is in your system, and then you're to come right back. If you fail to come back, or if you fail to take the drug test, I will revoke your bond, and I'm going to tell you now, you will not get any more PR bonds. Do you understand? Yes, sir. As a condition of your bond, I'm forbidding you from having any contact with Diana Morelli whatsoever, not to consume any alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. I'm also ordering you not to be in possession of weapons as well. I'm ordering you not to have contact with her. Can you find mom, please? Diana Morelli, please. Has a note been granted in this case? Okay.
I just put it ready for you.
Okay. So, guys, it looks like the CW is here, so.
Judge, I have all spoken with CW, and she says that her and her daughter have fixed the situation between them.
No, it's a second assault. Every time no. Doesn't matter.
Just go confirm with the CW.
Yeah, and well, I'm going to bring her in so that I can talk to her as well. Are you Miss Morelli? Hi. Thank you so much for coming. Would you mind coming up, please?
Okay, let's pause here because this is huge. The judge just found probable cause, which means there's enough evidence to move forward with criminal charges. But here's what makes this case particularly serious. This is the second assault charge against the same victim, her own mother. In Texas, assault of a family member carries up to a year in jail and a $4,000 fine. But repeat offenses? That's when judges start taking things very seriously. Notice how the judge immediately ordered a drug test and set strict bond conditions. No contact with the victim, no alcohol, no weapons. This isn't just precautionary. The police report stated the argument started because the mother confronted her daughter about drug use, and the defendant reportedly told police she was beating the living hell out of me. The judge is sending a crystal clear message. This pattern of violence yendies now. But here's where it gets complicated. The victim, the mother, just showed up in court. Why would she come? Is she here to support her daughter or press charges? Let's see what happens next.
I told her that I'm going to do everything in my power to protect every single person of Harris County, no matter who it is, who they are, what is going on, and that I would. And if that means putting them in jail and making it $100,000 bond, I will do it in a heartbeat. I'm entering now what's called a magistrate's order for emergency protection that identifies you as a protected individual. Ms. Morelli, You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? This is a second assault alleged against you. The first one was dismissed. However, now I'm forbidding her from having contact with you. I've also forbidden her from consuming alcohol or illegal drugs. And I'm sending her now for a drug test because I want to know what, if anything, is in her system. I'm so much as even contemplating putting a device on her ankle so I know that she's not consuming any alcohol. She has a lot of prior violent behavior, you know, and I'm going to do everything in my power to quell it. This is the fifth, violent type of case that we have. And that's it. Historically speaking, every 2 years, there's a new case since 2018. Stops now. Do you understand? Okay.
Am I allowed to say anything?
Well, I'd rather not. She has a lawyer, you guys can talk to the lawyer. I've got a bunch of DAs here and everything that you guys say can be used. And now's not the best time to talk about the case. The only thing I want to know, impart to you that you are now a protected individual, and I'm going to do everything in my power to make sure it stays like that so no one else puts their hands on you.
It's almost impossible for us to follow because I'm driving back to work and the 5 houses down.
Let's do this. I'm going to have her talk to the lawyer, and then we'll figure out something to do.
Did you catch that bombshell? The judge just revealed this isn't just a second case. This is the 5th violent offense this defendant has been involved in since 2018. That's a new case every 2 years like clockwork. This is a textbook pattern of escalating violence, and the judge is absolutely done playing games. He's even considering putting an ankle monitor on her to detect alcohol consumption, which can cost between $400 to $500 per month. And that comes out of the defendant's pocket. This is significant because alcohol was mentioned in the police report. Both mother and daughter had been drinking margaritas before the assault. The judge also issued a magistrate's order for emergency protection, which is essentially a restraining order that kicks in immediately. The mother is now legally protected, and any violation could mean instant jail time. But here's the twist. The judge is being very careful about what's said in court because the prosecutor is present, and anything discussed can be used against the defendant. Smart move by the judge to protect both parties while maintaining order. The question is, will this defendant finally break the cycle, or are we heading toward case number 6?
Well, we'll talk. For now, what I want to do is I'm going to send her for a drug test because I want to know what, if anything, is in her system. And then we'll have her come back, and hopefully by then the lawyers will be here and then we can talk. Okay? So just don't leave for now. Okay? All right. I'm going to have you sign this order for protection now, and then we'll send you on your way, and then we'll see you back in half an hour. Okay?
The last condition, Judge, if I could, it asks Ms. Morelli to contact pretrial to determine the case status. She has counsel, Judge. So can we remove that?
I've never seen that, actually. You'll have to show me that, what occurs. Usually it's something where it's random testing.
Do that, we put that paragraph thing. just
Why?
because I have no idea.
Okay, I'm gonna take that off. I don't see why. Thank you for bringing it. I've never seen that before.
I never seen either.
It was through the magistrate, so we'll take it off. Miss Morelli, I'm going to have you sign conditions now. You are not to have any threatening or harassing contact with your mother. What is threatening or harassing doesn't matter what you think is threatening. It's what she perceives. So if you buck up and go like this, is that threatening or harassing? It is. Spoken word, it doesn't have to be spoken word. Other conduct can violate this court order. If you violate this, I'm going to put you in jail. You will not get any more PR bonds. If I find that you're consuming alcohol, and I don't care what it is, I don't care what the source is, isopropyl alcohol, rubbing alcohol, a tequila lollipop, hair dye, NyQuil, I've heard it all, and it doesn't matter to me. No means no. And will take copious notes that I've warned you about everything, including mouthwash, Listerine, whatever it may be. If you test positive, the bond gets revoked, you go to jail. And from now on, if you test positive, I'm telling you now, I'm going to put an ankle monitor on you that tests for alcohol. And that thing costs around $400 to $500 a month. You understand?
Yes, Your Honor.
This judge is not playing around, and honestly, I'm here for it. He just laid out what might be the most comprehensive alcohol restriction I've ever heard in a courtroom. Isopropyl alcohol, rubbing alcohol, tequila lollipops, hair dye, NyQuil, mouthwash, Listerine. He literally listed everything. And you know what? He's seen it all before. Defendants will come back with positive alcohol tests and claim it was from mouthwash or cough syrup. But this judge is shutting that down before it even starts. He's creating a paper trail by explicitly warning her about every possible source of alcohol, so there's zero room for excuses later. This is also a glimpse into how savvy judges have to be. They've heard every excuse in the book. What's really striking here is the emphasis on perception versus intent. The judge clarified that what matters isn't whether the defendant thinks her behavior is threatening. It's whether the victim perceives it as threatening. A gesture, a look, proximity. Anything can violate the protection order, and the consequences are severe. No more personal recognizance bonds, which means she'd have to post cash bail if she violates these conditions. The judge is essentially telling her, this is your last shot at freedom. Use it wisely.
So everything in this order for protection will stay. The only thing that we're taking off is the residential restriction. So before you leave here, I would suggest that you get to know this thing so you know what you can and can't do. Do you have any questions?
I can contact her just and be around her, just nothing harassing or threatening.
No threatening, harassing, no alcohol from any source, no illegal drugs. Correct. You have a lawyer. They will take care of you. It's your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You will not get any more PR bonds if you pick up a new case, you start acting out, anything like that. Any questions?
Just Monday and Thursday to be.
You will report here at 9 o'clock in the morning. We'll send you the test. And then after that, you'll be go. And then you can go. If we find something we shouldn't, we'll get in contact with both of you guys. Okay?
Thank you,
If
Judge.
you don't show up, a warrant will issue.
Is there a time frame that it matters for those days?
9 o'clock here in the morning. Yeah, okay.
Yes,
We
All right,
excuse,
guys.
Judge. Thank you.
thank you.
Wait, did you catch that modification? The judge just removed the residential restriction, which means a defendant can have contact with her mother as long as it's not threatening or harassing. This is actually pretty unusual given the severity of the allegations and the pattern of violence we've seen. So why would the judge allow this? Well, it appears the mother and daughter want to maintain some kind of relationship, and the judge is willing to accommodate that, but with serious boundaries. The defendant can be around her mother, but the moment there's any threatening behavior, any harassment, any perceived intimidation, she goes straight to jail. No second chances. This is a calculated risk by the judge, and honestly, it puts enormous pressure on both the defendant and the victim. The defendant now has to constantly monitor her behavior, and remember that it's not about her intentions. It's about her mother's perception. One wrong move, one misinterpreted gesture, and it's over. The judge is also requiring twice weekly drug testing every Monday and Thursday at 9 a.m. sharp, creating a structure of accountability. This is either going to break the cycle of violence or confirm that jail time is inevitable. Which way do you think this is going to go? So let's wrap this up and break down what just happened in this courtroom. We witnessed a probable cause hearing for a second-degree assault family violence case with a troubling history. The defendant, facing charges for allegedly attacking her mother, has accumulated 5 violent offenses since 2018, a pattern the judge explicitly stated must end now. The court issued a magistrate's order for emergency protection, imposed strict bond conditions, including no alcohol from any source, no illegal drugs, no weapons possession, and mandatory twice-weekly drug testing. Interestingly, while the judge initially restricted all contact, he modified the order to allow non-threatening, non-harassing interaction between mother and daughter, a decision that shows judicial discretion balancing victim wishes with public safety. The defendant is now on the thinnest ice imaginable. Any violation means jail time, no more personal recognizance bonds, and potentially an ankle monitor costing hundreds of dollars monthly. This case perfectly illustrates the complexity of family violence prosecution, the legal system's challenge in protecting victims who may not want complete separation from their abusers, and a judge's difficult role in setting boundaries that respect relationships while preventing further harm. The bottom line? This defendant has been given one final opportunity to break a 7-year cycle of violence. Time will tell if she takes it. If you found this case as compelling and complex as we did, make sure to smash that like button, drop your thoughts in the comments. Seriously, I want to know what you would have done differently. And don't forget to subscribe for more in-depth courtroom breakdowns where we analyze the legal strategies, human drama, and real-world consequences of cases like this one.